Ladies and gentlemen, I see many, many empty chairs. Shame on those who are not here, because now is, even though it's a hard time, I know, it's the most interesting of all panels. We are talking about, and therefore welcome and congratulations to all of you who are here. You have made the... That's right. We are going to talk about forum shopping, which in itself, of course, is a highly interesting phenomenon. We spoke this morning, or we heard this morning already, something about harmonization of insolvency law. And it's probably, speaking as a European right now, not possible to do it on a political level. And for that reason, it's all the more important that we have something like forum shopping, because that is a demonstration, so to speak, by feet, which law is preferable over the other. And insofar, it's an extremely interesting indicator. And that is one of the reasons why we've chosen this topic. And because our dear organizer of the entire conference, at least co-organizer, Nacho, who is leaving the room right now, even though... No, where are you going? What are you looking for? Just sit down here. He is a little bit concerned. He's a little bit concerned that it's a full panel and we are just talking about one question. And for that reason, it's going to be for the next 3 hours. Change of program, so we have 3 hours. And insofar, it's good that he's out. Now, I keep, of course, the entire thing short, at least what I have to say, and I hand over the microphone to my co-moderator, which is John, and then I have a couple of questions which I raise and which I then hope to get answers from, and be the answer that there is no forum shopping in a particular region. Let's see. So, John.
Okay, so we're trying to do this as a little bit of a conversation panel, so we'll see if it works. And we've asked people from different jurisdictions to talk about the subject of forum shopping, as Christoph has outlined. So we have, you know everyone here, but we have an American, a Mexican, an Austrian, an Australian, and a Japanese. So we've decided deliberately to passive-aggressively leave the United Kingdom out of this for forum shopping. But you'll have to triangulate that through, take a little bit of Australia and a little bit of the United States, and I can be here from Canada. So what we've asked, Christoph has a list of questions we're going to go through and talk to the panelists, and we're going to allow and maybe even encourage the panelists to interrupt each other. But we thought just to get us started, we'd let everyone speak for just 1 or 2 minutes to kind of frame what they see the forum shopping issue as, or some issue from their jurisdiction about forum shopping before we start interrogating them. So why don't we just go down the row, and I'll start with Jay, if I may.
Thanks, John. The United States, of course, presents the model for forum shopping. It is the essence of forum shopping. It is the best and most mobile supermarket in the world. And the star, the star market, of course, is Delaware. I'm working on a database right now of 2014 cases from New York and Delaware, Southern New York and Delaware. And in Delaware, we took a sample of 50 cases. And of those, 2 have to do with Delaware. Now that's forum shopping, baby. You can come talk to us about how to do that. That's sort of the factual point. The other point is that a lot of people in the U.S. Academy who are interested in insolvency matters have written about the benefits of competition in law. And I can certainly see some benefits in that, encourage people to have more more well put together courts with well-paid judges and others to help them, and all those things. Those are clearly positive things. On the other hand, law is not a consumer good. Law is not something that we want to have a better toaster or whatever, because our view of what is better, of course, differs from one place to another. So I think we have to think seriously about whether or not we care. Is the process that we have in Delaware essentially simply an arbitration among parties who are both interested and well-heeled in order to participate? These are questions I think we have to talk about seriously.
Is it okay, Agustin, if we start with Japan, because that is something like the counterpart? Junko, could you give your initial statement?
Okay.
Thank you very much.
Thank you very much for having me on this panel. I would say that the Japanese situation about forum shopping is quite different from the other countries because unlike the United States, Japan does not adapts the federal system. So insolvency law, civil law, or civil execution proceeding apply to the same laws in all regions of Japan. So therefore, the forum shopping issues do not generally appear in Japan. And I would like to explain about how to decide the jurisdiction of insolvency cases in Japan. Firstly, there are no bankruptcy courts in Japan, and all bankruptcy cases belong to the jurisdiction of the district court. The jurisdiction of insolvency cases in Japan is all exclusive, and no jurisdiction by agreement is allowed. As a legal jurisdiction under Japanese insolvency law, if the debtor operates commercial business, the district court located in its principal place of business has jurisdiction. If its principal place of business is located in foreign countries, the district court in Japan, where its principal place of business is located, has jurisdiction. If the debtor is not a business operator, the district court, where his or her home address is located, has jurisdiction. The jurisdiction of all insolvency cases is basically decided by the provisions of insolvency law. However, if multiple companies, such as parent and subsidiary companies, file insolvency proceedings, the proceeding against the subsidiary may also be filed with the district court, which has commenced the proceeding against the parent company, in addition to the original territorial jurisdiction. Because it is better to proceed two proceedings at the same court in view of practical convenience or speedy proceedings and thereby cutting costs. Additionally, in case of large insolvency cases, insolvency law provides a special rule for the jurisdiction, territorial jurisdiction. When the debtor has more than 500 creditors, its insolvency proceeding may be filed with the district court located in the area subject to jurisdiction of the high court, in addition to the original territorial jurisdiction. The high courts in Japan are located in 8 large cities, Sapporo or Tokyo, Osaka, Nagoya, and so on. So the district court located there are also usually large in size and well organized and has abundant human resources,
Forgive
such
me,
as judges.
Junko, forgive me for interrupting. Could you shorten it a little
sorry.
bit? Thank you.
Okay, that's it.
Thank you. Thank you.
Perfect.
Apologies. Agustin, go ahead. Sure, go ahead.
Sorry. And one more, in case mega insolvency cases with more than 1,000 creditors, its insolvency proceeding may also file to Tokyo District Court or Osaka District Court because both courts has department specialized for bankruptcy cases. Yeah.
Thank you. Agustin.
Regarding Mexico, well, this is a conversation I did prepare for the panel. So I have 2 copies here of my presentation in case anybody is interested when the panel is over. I hope I'm not breaking the rules, guys. Okay, Mexico, I will just give the background of where we are before we get going with the specifics. Number one, I view the issue of foreign shopping as being grounded in the civil code and the commercial code. Look at this from the point of view or the perspective of a pyramid, where you start with civil laws, we call it, and then you go from there To the judiciary law, you go to the Federal Civil Procedure Code, and finally, the Mexican Commercial Insolvency Concurso law. It's all related, and many decisions that you find in this area may arise in the context of commercial litigation in general and not be related to commercial insolvency. Regarding forum shopping, I would say that if we think of a contract, any kind of contract, you have applicable law and you have governing law, applicable jurisdiction. So what we're talking about here is both. That's how I read our panel, not just forum shopping strictly. And why do I say that? Because in Mexico, we don't have special bankruptcy courts. So you go to the commercial district courts for any bankruptcy proceedings, and that's the beginning of your analysis. I leave it there.
Okay, good. Bettina?
Thank you. Well, to be short, in Austria, we don't have special bankruptcy courts either. Maybe I should start with that. But we do have special departments. So we have specialized judges who know they really know what they do. So they are really very, very good. But regarding forum shopping, one thing I'd like to stress is Austria could serve as a kind of really counterpart maybe to the US. So we are not exactly a role model. We are not maybe we are not attractive enough to be shopped. I'll explain why if you like. So it's, our basic attitude is something like it's like much ado about nothing, just without a double wedding at the ending. So there is the Heidelberg report dating from 2013, and it only mentions one relevant case in Austria. So this is not exactly a mass phenomenon, you could say.
Bettina, be a little bit less shy. Don't present yourself just as an Austrian, present yourself as a European. And there we have a lot of forum shopping.
I do. Well, Christoph always, thinking big. So we are not attractive enough to be shopped, but of course forum shopping happens so that someone tries to, I don't know, to abuse the relocation and get an easy discharge, but I think we'll talk about that later.
Okay.
Yeah?
Okay. Scott?
Thanks, Christoph. I'm scared as to what direction I might get, but I'll be brief in my opening. I've been forum shopping for about 10 years or so, and sometimes I've squeezed in some insolvency practice as well. And what I was interested to see when I looked at this topic, because a little like we've just heard from Bettina, Australia's not really a destination jurisdiction for forum shopping. So I was surprised to see that the first quote that came up when I looked at forum shopping was in fact from a judgment of Lord Denning in 1983 in the Smith-Kline case. And I think this is an interesting framing piece to my mind. And the relevant part of the quote is that as a moth is drawn to a light, so is a litigant drawn to the United States. And I must say, this is an occupational hazard for practitioners in insolvency and bankruptcy in Australia. So we constantly have our moth clients, I say that with the greatest of respect, none of whom are here, wanting to be drawn to other jurisdictions, but we don't seem to see as much favouritism directed back towards us in a reciprocal way. There are some colleagues here that I've referred matters to in other countries throughout the years. So it's interesting, and I'll elaborate beyond the initial opening remarks as to why that could be the case. And I'll just make one other reference to an interesting decision that I think frames another part of the argument, and as we're in Spain, it seems to me to be entirely appropriate. This is from the Fourth Circuit Court's decision in 1987 in a case of Goad and Celotex. And I quite like this pithy quote: "There is nothing inherently evil about forum shopping, but it depends on whose ox is being gored." And I think that's perhaps why the tension sometimes comes out in forum shopping discussions.
Yeah, so I'd like to maybe open up this question, and I can, both Bettina and Scott have raised this theme, but others can jump in, which is one aspect of forum shopping is looking for an attractive jurisdiction, and we can debate how we define attractive. But on the other end, if you're in a non-destination jurisdiction, as you have self-described Austria and Australia, what, if any, legal mechanisms are there to police shopping? Like, can you get an injunction to say you shouldn't be filing in the States? Come back here to Austria. Are there legal mechanisms for that? Do they do that? Is there a will for that or not?
Right, so in Australia we certainly have all of those devices available, including anti-suit injunctions as understood throughout other jurisdictions, and the way that our highest court has approached the principle is slightly divergent from what you'll see in some other jurisdictions, but it's essentially on all fours. But if I could just put a stake in the ground for a discussion later on, and that is, I think a lot of countries are not sitting complacently observing this development pass them by, but rather are looking to take reforms to their own laws to try to indeed stimulate the amount of restructuring and insolvency activity that could be imported. And the standout example in recent years that we could survey the room to see if everybody would agree, but there is no question that there has been a lot of discussion, quite appropriately, about the lengths that Singapore has gone to this end. But Singapore is not alone in that regard, and it opens up a very interesting discussion about competitive opportunities in insolvency law reform.
So we don't really have an instrument like that to bring a case back to Austria. So we are really, I don't know, very continental in that aspect, I think. And I don't know about Germany. You don't, do you?
I mean, we had recently a German-Austrian case, which was extremely famous, at least in this region.
You want to talk about Niki?
Do you want?
Yes.
Oh, wonderful. Why don't you tell us a little bit about the Niki case?
Well, the Niki case is, because, you know, I talked to Ulla Reisch the other day. Yeah. She was the administrator in Austria. And she told me the problem with Niki was that it was not a COMI problem, of course. COMI was supposedly in Austria, but all the infrastructure, of course, is in Germany. So she had nothing to, she didn't get any information, which maybe, well, one part of the problem maybe was the German administrator, if I might say that.
Yeah,
I don't know.
You may. Can I briefly interrupt in order to get the audience on top of the Niki case is famous insofar. You all need to know Niki Lauda. He just passed away recently, didn't he? And he once gave a presentation in Vienna and to Insult Europe, and he was saying he's the only person on earth who finds in the skies his first and his last name. So there was initially the Lauda heir, that was the last name, and then that had to be sold because of closely insolvency-related reasons. And then he founded a new company, and that is Niki Air. So he had the chance, at least for a while, to see Niki Lauda flying along. And the Niki Air was part of the Air Berlin, and Air Berlin was a daughter company, an affiliate of the Etihad, and they went bankrupt, something like 1.5 years ago. And then there was the big fight, it was forum shopping par excellence, that the Air Berlin, the mother company, is located in Berlin, in my hometown, and they organized the entire group more or less from there. And the Niki Air was, to a certain degree, in Austria. And then the battle, of course, began between the two countries. Is this a German or is it an Austrian proceeding? So that is the background of the fight. And in Berlin, there was already appointed a preliminary insolvency administrator. And he, of course, claimed that this is, of course, a German proceeding. Then there were some procedural intricacies which led to the consequence that there was a tiny loophole of something like 2 weeks in which the Austrian judge jumped in by means of an permissible, nevertheless interesting interpretation of the statute, which gave him the power to say, I open an insolvency proceeding in Austria in accordance to the European insolvency regulation. That means the main proceeding was opened in Austria. So insofar, it was a paradigm of what we are talking about. And it's a battle for, I don't know exactly what, but I can tell you as a European, it has very much to do with national sentiments and feelings. The feeling we do it better than they, it's our case rather than their case. So there's a lot of emotion in that, and that makes it extremely interesting. Emotions discovered then by legal arguments, of course. Forgive me.
No. You have said almost everything. Thank you so much. I don't. Just one thing I have to add is that she said, well, the Austrian administrator told me that the most problematic thing for her, issue for her, is that the COMI, as I said, supposedly is in Austria, because from the outside, regarding the customers, the client's view, everything is in Austria, but all the infrastructure, the logistics, etc., are in Germany. So she said she couldn't really work. So that's really her problem, and that is one of the things we also have to think about. I think when we have this discussion about forum shopping, what it leads to, and if there's let's say a splitting between the COMI on the one hand and the infrastructure on the other hand in another country, and that's a bad thing.
Okay, about Mexico, we have a dual system. We go for the corporate domicile, as stated in the charter and bylaws, and then in terms of the commercial insolvency law, you also look to the main place where the administration is located in case the corporate domicile, and that is the term, is unreal. So it is real because it is even publicly recorded. Unreal would be that there's nothing there, and we've seen many cases cross-border. In the case of COMI, which is equivalent to our main place of administration, I was thinking that we have a system that may give rise to the following. In the US, we have trouble following sometimes from abroad the fact that decisions are different depending on what circuit is deciding. So on the same issue, you have different decisions, and then you have to reconcile that, and then you may go to the Supreme Court or have legal reform take place. In Mexico, we normally don't have as much in terms of that, but in terms of group reorganizations, which is a fairly new concept in terms of development in Mexico, I was thinking you can qualify for protection if you're insolvent only, or if you will be imminently insolvent. So if you have a group with a COMI that is, say, in Mexico City, but you want to commence your proceedings elsewhere, I'll say Guadalajara, you can use one of those subsidiaries and file there and qualify for protection, and that will be the court with the first jurisdiction for the group proceedings, so that if anyone else wants to commence proceedings anywhere else, or the debtor, they can go to Guadalajara. That is really the response to factual considerations, not legal. If I want to pull everybody into Guadalajara or any other place, forget the name, to make their lives difficult, more expensive, then I bring them to that place and forget about the COMI for the entire group, which could be arguably situated somewhere else.
Jay, does that sound familiar at all to you?
It does indeed. We have exactly that kind of rule. Your nearly collapsed Delaware subsidiary files in Delaware. It's one of 30 subsidiaries of your large company, and the rest of the company just troops right along behind, including the parent company that actually controls the entire group. That's why you can file in Delaware, or really anywhere in the U.S. virtually, if you're a larger company. We have a rule that says, however, that you can, the parties, particularly the creditors, of course, can move for a change of venue back to where they say was the right, the real center of the case, the real center of the company. But there are jurisdictions, and Delaware is one of them, where one really is not clear. That very often that sort of motion is given much attention, and indeed it is very often denied. So as a result, it is possible to go to a place where there is no real connection with the business of the company, but nonetheless you can file in Delaware. That's why I can say quite accurately that out of 50 cases in our sample in Delaware, in our empirical sample in Delaware, only 2 of them are actually Delaware cases as far as we can tell. That's a pretty dramatic change, and it really means, as I said before, Delaware is virtually an arbitration method for resolving corporate reorganizations, and you can decide that that's a good idea or a bad idea. I'm inclined to be a little bit unsure about that. And you should know this, just to finish, Christoph, you should know that there is pending now quite a movement with some really strong political support to change those venue rules, marked notably by the hysterical fact that Senator Elizabeth Warren and Senator John Cornyn, who do, the latter being from Texas, of course, who probably don't agree on a single other political principle of any kind whatsoever, are the joint sponsors of a bill to eliminate this venue rule and to say that, in effect, the corporate group would have to file in its principal place of business. So there's quite a controversy about this, and it will continue, I think, to grow and develop in the years ahead.
Can I ask, Agustin, so let's say the Mexican company's real seat is in Guadalajara or wherever, but they, under the U.S. laws, they left this Kleenex in New York. So they say, well, we have jurisdiction, we're going to file Chapter 11. Does the Mexican court have any power or authority to say you can't do 11, you've got to go and dismiss the 11, or they just have to take the 11 and it
No,
goes
the
away?
courts wouldn't act unilaterally or motu proprio. They would need for the litigators to challenge and to try to direct the proceedings here or there. So in terms of how you defend that, there you have rules. For example, is that the place where a contractual clause was agreed upon that you could be served and tried during the course of the relationship? Is that a place where the obligations will be complied with? And that's when you start forming a good file to make your case that certain jurisdiction or another is proper. You cannot be arbitrary about that.
So, and is there litigation on that? Is there litigation, like do people fight over that and you win sometimes, getting the case to come back?
Yes. As I was saying, not always in the context of concursos or reorganizations. In commercial proceedings, it is very often the case. You sue in your home court, and then they will say, no, we didn't agree on anything, because there's different types of domicile: conventional, legal, personal, which means individual, corporate, and so you will have to fight that in court, and the court will look at it and also decide on the basis of what is my caseload, right?
Yeah, right.
Frankly, and my resources.
That is a very universal concept.
And yet, if you'll forgive me,
No.
one of the interesting premises, well, you never forgive
I don't forgive you.
In one of the interesting premises that we have in the U.S., not everybody shares this premise, but many people do, is that certain judges like to have large, complicated, interesting, yes, international cases in their courts because they're interesting and because they produce a great deal of prestige for the judge who succeeds in putting together a financial case. And of course, it's not the worst thing in the world that happened to the lawyers in that district either. And so there's a claim that the judges are reluctant to let those cases go,
True.
and that's an important part. Now, of course, no one's done that study, certainly not me. But I hasten to say that. But that's a premise that many people have in the States.
I would like to clarify something from Mexico. And I would say that in Mexico happens the other way around. Most judges don't want to take insolvency cases. So they, by ex officio, they reject on taking jurisdiction. And they raise issues like service of process, jurisdiction, and some others. So the common rule is the other way around. And we have to fight a lot this kind of situation. This is irrespective the right of the counterparty to object service of process and jurisdiction. So, and we have to fight sometimes for years, meaning 4 or 5 years.
All right. No, not normative. I mean, that's an interesting idea. We are talking more or less about the concept of the komi. I mean, behind all this is the concept of the komi. And the way how I understood your question is, the fascinating idea is there's something like an anti-suit injunction possible in insolvency cases. And my question would now be to Junko. What would happen if a Japanese company would say, no, I'm not going to Japan, I'm going to Singapore? And the same question then to Scott about Australia. Would you have in your law an action or a possibility, a remedy against this? First of all, do you have a remedy? And secondly, would it be effective? I mean, that's the other part. Junko?
Why don't I'll just give a response to that from an Australian perspective, okay. And Junko and I will confer. So I can give you an actual example in Australia, though there was no anti-suit injunction outcome, but anti-suit injunctive relief does exist in Australia, which would be the Australian court then seeking to restrain in Australia the litigant from filing offshore, and that does happen from time to time. But this example that I have of an instance where creatively a problem that dealt with some of our local insolvency laws was in fact cured by some forum shopping that was very good forum shopping, and I think the stance we tend to take in Australia is that most forum shopping is generally good if it stimulates cross-border insolvency activity. But this case was quite interesting because it was the first time that Australia decided to build its own satellite, which actually never did get launched. It might have been recycled in an aluminium heap. But the satellite company was incorporated in Australia, and the construction of the satellite, which was being done by a company called NewSat, was actually being delivered by Lockheed Martin in the United States. And satellites are very expensive to build, as it turns out, and the Australian company came into real difficulty in being able to finance the construction. But at that time, we had not reformed our ipso facto regime, meaning that an event of insolvency would have entitled Lockheed Martin to terminate the contract, and there would have been absolutely no chance of the satellite being completed, and the value destruction would have been substantial. So what happened to cure, at least theoretically, that risk is that the Australian company went into voluntary administration in Australia, which is a very conventional response when directors are concerned about insolvency being imminent. But simultaneously, only 3 hours later in the United States, in Delaware, filed for Chapter 15 recognition. It turned out that NewSat had some operations also in the United States. So this was timed very deliberately to enter into voluntary administration in Australia. 3 hours later, Chapter 15 recognition in the United States, with some ancillary relief seeking to restrain Lockheed Martin from terminating under the ipso facto clause the supply contract, meaning that they were locked into their obligations to continue to build the satellite. Now, the tale to the story in the end is that the financial obligations under the contract were not met, and the contract was ultimately terminated, and the satellite, I think, was scrapped. But it is a great example of why forum shopping, quite legitimately and properly, and without any sense of it being for improper purposes, could be and was quite rightly pursued in that situation. I know that's not a direct answer to your anti-suit question, but if it was thought that by the Australian jurisdiction or courts that there was some problem with that pursuit, then certainly the Australian court could have intervened and sought to restrain the local Australian voluntary administrators, who are officers of the court, from pursuing offshore litigation.
Okay.
Scott, does Junko want to comment?
Yeah, do you have an example from Japan?
Thank you.
Sorry, I didn't have. I'm sorry, so I don't have the thinking about that. So I research the cases later there. Thank you.
So that brings me to a question. I think, Bettina, you have raised this already. My second question, which I have prepared, is what is wrong with forum shopping and what is the underlying rationale for the opposition? And in this context, I can't refrain from mentioning once again what I'm always doing, and you're bored by that, but that I'm also a legal historian. And that reminds me, this story reminds me of that in late antiquity. It began with the peasants. They were all of a sudden, for tax reasons, they are bound to stay on the place where they are, and they were bound to take over the job that their fathers had. So if they were fleeing, they were, when captured, they were killed. And that is a tax enforcement system. And there, it sounds like silly because it's in late antiquity, but I was reminded of it when a quite famous tennis player, a German tennis player, Boris Becker, when he was found out by the tax authorities that he has moved his domicile to Monte Carlo, but he didn't stay there for 180 days or 181 days. That's the obligation. You have to be longer in that city than in Germany. He failed to fulfill the time period by 1 day. And for that reason, there was huge discussion in Germany because he was fined by the tax authorities that he had to pay a couple of millions. And there was huge discussion about that this is not doable, that the famous rich people can move their seat from here to there in order to avoid the German tax system. I mean, that is forum shopping. That is forum shopping in the clearest sense. And my question in this context is, what's wrong with it? We have heard now already by some of you saying that nothing is wrong, at least in some cases. And now I'm asking you, what is your understanding? I begin with Jay. What is your understanding of, is there a good and is there a bad forum shopping? That is what the European insolvency regulation is alluding to, that there are two types of forum shopping.
Well, so the classic example in Texas, where I come from, is Enron Corporation. If any of you were old enough to remember Enron Corporation from the early 2000s, an absolute nest of fraud and deceit and all those things. And it, of course, was a Texas company. I say, of course, was a Texas company. That doesn't sound right. But you know, of course, that it was a Texas company in Houston. And the case was filed in New York, again, through this subsidiary going in first device. And there was a great deal of resistance. That's why John Cornyn, who is now a senator but was then Texas Attorney General, was desperately unhappy about the fact that this Texas company was going off to New York to be reorganized. And for months, we saw these pictures of the Enron employees in Houston, downtown Houston, marching around with their signs because they had been encouraged to invest all of their retirement savings in Enron stock. And they were really quite annoyed when that stock became worthless. So for a lot of people, that kind of symbolizes, I think, bad forum shopping in the U.S.
And I would add that more than the forum shopping being wrong, in my opinion, we will never be able to grasp the issue of COMI as applicable to all cases. If you look at group reorganizations, you play around with COMI. So COMI is a nice concept and it's a useful concept. We in Mexico have embedded it in various ways and it works, but it isn't universal and it isn't always applicable in my view. And that's what makes this subject uncomfortable.
I agree, I think that's right.
Bettina?
Well, if you ask me if there are two kinds of forum shoppings, or if it could be good or bad, I mean, of course, as you all know, obviously everybody, at least in Europe, is entitled to relocate, which is guaranteed by fundamental freedoms. But I might remind you that the European Court of Justice has issued the Kornhaus decision, which has kind of recognized that the creditor's legitimate expectations kind of limit these freedoms a little bit. So this is something we should also think about when we talk about forum shopping. So forum shopping, at least in my view, is nothing bad per se, of course. Everybody is free to choose the easiest way to get rid of his or her debts. But, and this is also the opinion of our legislator and of the German one too. I might think, when it's abusive, and but this is a common knowledge, of course. It's one thing is also problematic, at least in my view. It's if the debt relief is recognized in other states, then the pressure on the other states that recognize the debt relief is greater to facilitate debt relief themselves, so that the state's decision on the extent to which a debt relief should be possible is influenced by external circumstances. So this is something which is kind of problematic in our view, because we are rather, I don't know, like reluctant regarding debt relief, and we don't really want that pressure. Our legislator wouldn't really want that. Maybe this is something we could also discuss on that.
When you speak about expectations in this context, whose expectation are you referring to?
The creditor's expectations.
Can you speak in
The
microphone?
creditor's expectation.
Whose creditor? Which creditor? Which one of the creditors? Which one of the creditors?
The unsecured ones, mainly. Or maybe all of them. It was not so clearly said.
Okay. Scott?
This is like the cross-examiner pressing to get the answer that he really wants.
Yes.
So I'm going to continue to resist the invitation because I'm so optimistic about forum shopping. But I've got a few more of my quotes that I've dug up for the purposes of the presentation, and this one is the counter proposition, I guess, and it's from a case, the Atlantic Star, and it's Lord Simon Glasdale. And Lord Simon Glasdale said that forum shopping is a dirty word, so there's the concession for the cross-examiner. But it's only a pejorative way of saying that if you offer a plaintiff a choice of jurisdictions, they will naturally choose the one where they think their case can be most favourably presented, and this should be neither a matter for surprise nor for indignation. And I think it's a neat retort to the proposition that we need to be careful about boxing forum shopping into good and bad categories. And there was also a very recent study, or it may not be so recent now, by 2 Cornell Law School professors of corporate bankruptcy filings, and they had undertaken a longitudinal study. And they concluded that people file for bankruptcy and shop for judges the way that most people shop for groceries. They always look for the best deal. And I think from the perspective of a practitioner, this is the reality in day-to-day practice, and it may not always then turn out favourably from the perspective of looking at cases retrospectively and trying to understand why people did certain things and whether it was good or bad. The side of forum shopping that I think has perhaps been least spoken about, but is maybe its greatest contribution to jurisprudence, or at least to our industry, or one of its greatest contributions, is that it's been a stimulus for insolvency law reform. And we have seen many jurisdictions. I've already mentioned Singapore. Singapore is not alone. We know that last November, the Secretary for Justice in Hong Kong announced that there would be reforms of the Hong Kong system to perhaps modernise it or reform it to make it more attractive to restructuring in a way that Singapore had clearly identified was an opportunity for it. Australia also realising that we've got what's often regarded as the most draconian insolvency laws in the world, because we still send people to jail for insolvent trading in certain circumstances, and luckily not very often, has realised that we need to reform our laws. And so we now have a safe harbour regime, and we've dealt with ipso facto challenges that mean that it's more attractive to file in the jurisdiction. So while we are perhaps very concerned to segment forum shopping into good or bad, I think what I've found most interesting about this field, especially over the past few years, is the stimulus that it's created for countries to reform their insolvency systems and modernise them and try to, in fact, make them rise to a higher standard rather than fall to a lowest common denominator.
Could I put forward
Yeah, please,
a
please, please.
hypothetical, if I may? Because I really think this is a really important issue, Scott, you're right. And it seems to me, suppose we have, you gave a great example, two jurisdictions, one of them being the one where the company is more or less concentrated, and of course that isn't always the case. We don't always know about Comey, but let's assume this is a fairly easy Comey case, in which, and in that jurisdiction, there is a rule that says you can't enforce ipso facto clauses, as there is in the United States. So the mere filing of bankruptcy is not enough to get the other party out of the contract. That's what the Comey country says. And another country that has rather less connection with the debtor says, oh no, you can't do that. We can throw out the contract. Or we can and should throw out the contract if it has an ipso facto clause. It seems to me in that situation, one jurisdiction has decided, rightly or wrongly, that it's a better idea to block ipso facto clauses to encourage reorganization. That's clearly the genesis of the American rule. And another jurisdiction said, no, they contracted for this, and there's no reason not to enforce the contract. If the Comey that would keep the plant open, as we say, says that you shouldn't be able to do that, isn't that an important factor? And wouldn't the Comey be entitled to say, no, our company shouldn't be running off to some other place, who knows where, to say that that's a bad thing? And the reason I want to raise this, particularly, is not only our abstract discussion of the justice of one way or the other, but the fact, at the end of the day, reorganization is a process of discharge. A whole new debt structure is set up, the old debt structures are out. That's the way it has to work in order to be successful. And that means where the assets are, where the plant is in my example, has to be a jurisdiction prepared to enforce the reorganization. And I'm guessing that on the facts I've read are artificially presented, the jurisdiction where the plant is and will close if it enforces the judgment for the other place is going to be very reluctant to enforce that judgment. And if that's the case, then the whole system has broken down in a serious way. I don't know if anyone thinks that's a hypo worth discussing, but I think it presents some of the issues that we should talk about.
Junko, do you have?
And as I mentioned, the jurisdiction of insolvency cases in Japan is decided under the Japanese insolvency law. So I think that there is no good in forum shopping and bad forum shopping. But actually, in practice, it is fact that insolvency cases concentrate in Tokyo District Court or Osaka District Court, especially in case of corporate reorganization, which is the reorganization proceeding for large companies, and also civil rehabilitation proceeding, which is the proceeding for small and mid-sized companies. So corporate reorganization and civil rehabilitation cases is concentrated to Tokyo or Osaka District Court. Because this main reason is because there are many companies in Tokyo and in Osaka, especially in Tokyo. But as I mentioned, there is no bankruptcy court, and so in local district court other than Tokyo and Osaka District Court, the civil department dealing with the ordinary civil cases also handle insolvency cases in local district court other than Tokyo and Osaka. So the local district courts are small in size and sometimes not enough manpower, and therefore there are not many judges and law clerks and lawyers who have experience dealing with the reorganization cases. So many debtors tend to file reorganization cases that require many debtors tend to file reorganization cases at Tokyo and Osaka District Court, where there are a large number of well-experienced judges, law clerks, and bankruptcy lawyers for reorganization cases, because these courts has a department specialized for bankruptcy courts. So that's a very different situation from the other countries. There's no battle for good forum shopping in Japan, I think so.
Well, Junko brings up a good point, which is if there's formally no forum shopping because there's no discretion over where the jurisdiction attaches or whatever, it makes us broaden or reconceptualize our understanding of what it means to forum shop. So I would submit as a proposition that if I am a Japanese company and I don't like the consequences of the Japanese law, what I will do is forum shop by trying to relocate my company to a more congenial jurisdiction. And then the Japanese court's conduct doesn't affect me if I've migrated. So there will always be some sort of forum shopping. Now, we've discussed the normative merits. Is it good or is it bad? You know, are we racing to the top where we're having the most efficient insolvency laws, or are we all swirling down the toilet drain together? And it strikes me that there must be some conception of bad forum shopping, because most of the legal regimes that we talk about they just don't want to let go of some sort of carve-out that say, well, no, it's okay to move unless there's abusive forum shopping, or we have to have some way of policing what we think is abuse. So undergirding that must be some idea that sometimes it's bad. And so the question is, how do we know when it's bad? Can we try to delineate the substantive conduct, or do we just look for procedural indications, like anytime someone moves, we think that's fishy? What do we do?
I mean, we have in Germany, just in order to raise this discussion, we have in Germany a phrase for that, or a flag for that, and that is the burial of companies. And what it means is that companies are trying to circumvent the insolvency law, probably primarily the insolvency law, and migrate from, let's say, a tiny little place in Germany, somewhere in Germany, to a tiny little place on the Spanish coastline. And there they open their liquidation proceeding, which is just a plain liquidation with ignoring all the creditors and all that what are leftovers kept back in Germany. And that is something where we, under German law, fight against by means of tort law. So is this a remedy which is known to you other guys as well?
Well, the concept of forum shopping is not used in Mexican statutes. Let's start from the outset. Yeah. One way or the other. There is no good forum shopping. There is no abusive forum shopping. So what we have is rules that will lead you to the best jurisdiction for the case, and also depending on how the lawyers are trying the case. But I'm afraid that if we were to define this will be considered to be abusive forum shopping, we may write an entire statute, an entire law as we call it, on the subject, which would be very casuistic and then in the end be applied by the courts.
And whatever you wrote that law, you'd think really long about what was all the bad forum shopping. Then the smart lawyers would just do this, which is just outside the law.
You know smart lawyers. Yeah. Terrible.
Jay, what do you think of the tort of wrongful filing?
Bettina?
Or, sorry.
Can you pull the microphone a little bit closer?
A little closer?
Yeah.
Okay. So you have to explain that to me. What do you have in Germany?
We have these companies. They are pretty much over-indebted. And instead of going through an insolvency proceeding, it's a violation, first of all, of a duty to file. They just migrate, silently, of course, to Cyprus, to Spain, to a tiny little place somewhere in another country, and hope to disappear from the scenery. And whatever they do, they leave the debts behind.
And the remedy is
And then once they are discovered, the individuals who are behind this company, they are discovered, then they are put, of course, it's criminal sanctions also, but the private law sanction would be under, because we have no other thing, we have the tort law.
It's exactly the same. I mean, of course, that was what I wanted to mention, the criminal law, of course, and tort law, because of not filing properly for insolvency in Austria. That would be the consequence. It would be just like in Germany.
A nullity, legal nullity. It would be like a legal nullity. The German wouldn't recognize the discharge.
Yeah, right.
That's torts because it is bad faith and you're causing damage to the third party.
Yeah, I mean, obviously migration is a difficult problem. It doesn't come up so much within the United States because there's always Delaware. But, and of course I'm being flip when I say that, please understand that. But nonetheless, there is a lot more room. You know, we used to be a frontier country and you could just leave your debts behind by going west. We don't have that anymore. But I do think that it's not a very effective remedy, or at least it doesn't seem to me to be a very effective remedy, particularly in the context of a modern corporation that's functioning on a going forward basis. Now, if you're just having a liquidation in some obscure place, that might be a solution. But if we're focusing on reorganization, it doesn't seem to me that a tort remedy is very good. And it would have to turn on the suing the individuals, I guess. I mean, suing the company at this point is not very useful. And the individuals, guess what? They're going to migrate, Christoph, right, to an appropriate place with nice beaches and no reciprocal enforcement arrangements with the United States.
Forgive me one more historical remark. I mean, for centuries in Europe, another term for bankrupt has been fugitivos, the fugitive, the one who fled.
Yeah.
What about, Scott, what in Australia, do you have migration? Do people try to get away from these draconian laws where they go to jail? Do they plan their insolvencies by getting a passport?
Look, I think they'd like to if they could, but it's very difficult because I think whatever they leave behind certainly is potentially enough to attract regulatory investigation, and if it transpires that the conduct of the directors has caused the company to become insolvent, or if it's traded whilst it's insolvent and the directors are still somehow within the jurisdiction or they're able to be brought into the jurisdiction, then there is, at the worst, as I mentioned before, likely possible criminal punishment. So there are quite strong incentives in the Australian system to make sure that corporate affairs aren't quite treated in the way that you've been describing. I'm sure that through corporate structuring and restructuring, companies are constantly re-domiciling themselves, and indeed some countries and jurisdictions around the world have now made it very easy to migrate the registration of the company and to receive recognition. So for instance, and I don't want to misquote the position in Singapore, but just sticking to my backyard of Asia, but there are, for instance, legislative arrangements now in place in Singapore that would allow a company to seek to re-register itself in that jurisdiction upon meeting certain requirements. So the ease with which migration can happen is being facilitated. And this goes back to my general thesis in this area, which is that I think there's more framework and architecture in place to facilitate forum shopping than there is principle and resistance that tries to discourage it. And so some obvious examples I would give that I think align in this way is the model law on cross-border insolvency. I don't think there's an instrument I can think of that has been more effective in facilitating forum shopping and enabling the seeking of relief in jurisdictions beyond the COMI jurisdiction than the model law on cross-border insolvency. And for those that have been following the evolution of model laws, we've of course now awaiting adoption by the model law on recognition and enforcement of foreign insolvency-related judgments. And in the first week of August, we'll have the latest model law, which is the model law on recognition of mediated settlement agreements. And I just think that if you take a step back from this package of global architecture, all of this is designed towards certainly not discouraging forum shopping, but indeed facilitating the ease with which debtors can seek relief in any jurisdiction around the world that's a signatory to such an instrument. So yet again, I resist the invitation of the cross-examiner to say something bad about forum shopping.
Okay, I'm going to give Junko a chance to say any last words that she'd like to, but before I give her the floor, I'd be curious in conducting a rigorous empirical experiment, which is, I'd like to know from the real lawyers and practitioners in this room, without revealing any confidences, by a show of hands, who's been involved in trying to migrate companies or move them or forum shop, however you define that. I'm going to say that's the vast majority. So clearly that's the thing, that's our business, that's what we do, right? That's our bread and butter. Okay. Junko, do you want to make any other comments on forum shopping?
So today I introduced the Japanese situation, Japanese domestic situation about forum shopping. But when cross-border insolvency cases in Japan, Japan has also the exact program about forum shopping, which is better the court to file the proceeding, the Japan or the other countries. But, so the Japanese situation is quite different from the forum shopping. In the meaning, it's a quite different situation from the other countries. So the Japanese, in sense of the Japanese forum shopping is due to the structure of the courts in Japan. And because there is no bankruptcy court, and so other than Tokyo and Osaka District Court, the local district court has no department specialized for bankruptcy. So it can be said that forum shopping issues has taken place in Japan. It's a very different meaning of that in foreign countries.
Okay, we have about time for one or maybe two comments or questions from the floor, if anyone would like one. Yes, that young gentleman in the front looks like he has something he wants to say. If only we had some sort of international organization for harmonizing law.
Sorry, it was the reference to moving to Spain, and when they say Spain or some other obscure place, then I thought I should say something about it. Well, the truth is, this is not that easy, because if you have a German company and you just transfer to Spain, you have to leave some sort of notice in the registry of companies in Germany. You definitely have to leave a trace in the registry of companies in Spain. Therefore, if no one finds out about this company, we've got creditors that don't give a damn. Because if they give a damn, they'll identify this creditor and they will do whatever they need to do. So it's not that easy, really. I mean, unless it's a factual thing and there's no legal transfer.
I mean, that's obviously the underlying pattern of what they are doing, and it's an entire business as far as I understand. They do more or less on the factual basis, and they disappear from the scenery. It's a reappearance of the fugitives in medieval times.
So it will be declared insolvent in Germany?
No, they go to the register here, and they get registered, and then they are disappearing as quickly as possible. Don't ask me for the details. I'm an academic.
Howard.
That was an absolutely fascinating discussion. Thank you all. Someone this morning talked about the power of the market in shaping the law. And the reality is here that we are, as Christoph in his examples give, we're trying to stand in the way of change in the same way as the sumptuary laws sought to preserve the feudal order. Regulatory competition means that the market will flow to the jurisdictions where they get the most expedient results. And that isn't necessarily those with the lowest standards, because there is a tacit, unspoken accommodation between market players on either side of disputes as to what works. Hence, Delaware works, notwithstanding the criticisms that are made of it. Ruritania, where the judges will take payments to give orders that favour the debtor or the creditor side, won't work because the market won't tolerate it. And gradually, the great thing about global insolvency is that we are converging on solutions which bear great similarities. Not smoothly, because it's not done by conscious effort, it is the tide of the market. So I think, one, we can't stop it. I agree with what Scott's saying. And secondly, we need to embrace it.
So let me close by asking one more question with the show of hands. And I won't put you on the spot so you can say, it wasn't me, it's someone else I worked with, or someone on the other side of the deal. So has anyone here, by however he or she wishes to define it, been involved in a circumstance in which they think there was wrongful forum shopping or wrongful migration of a company? So I'm going to say I got at least about a third of you are putting up your hands. So it means there's something out there. We may not have defined it, but it is something out there, and it's a phenomenon. And so with that indeterminacy, that's a great way for our panel to end. Please join me in thanking the group.